So a workplace retaliation suit is an ex-employee suing you saying they got fired because they complained about something in the workplace and that was legally protected. So said differently, somebody complained about some sort of safety issue or violation of the law and that you fired them because of that, rather than you just fired them because they're a bad employee and they really shouldn't be on your team. So for example, let's say Sally complains that the boss is sexually harassing her, and then instead of the boss getting into trouble, the company just fires Sally. So now she's got a wrongful termination claim and a retaliation claim. So the way it works is if somebody complains about some sort of safety issue or some sort of violation of law in the workplace and then they get terminated, then they can potentially bring a wrongful termination claim or a retaliation claim. So number one, make sure you document your employee's performance. You want to make sure that you've got a record, especially if they're underperforming. It's going to be really difficult if you say, well, this person was never a good employee, but there's no write-ups and there's nothing in their file to help support what you're saying. Number two, make sure that you consult with somebody before you end up firing an employee. I've seen this where clients will come to us after they fired an employee, and shortly before they were fired, that person had complained about something or said that they were hurt on the job, and then they were fired. And the clients always say, well, this person was a terrible employee, I was gonna fire them anyways. And that many times isn't that great, because there's something known as temporal proximity. Said differently, it was close in time to them complaining about something and them being fired. So that's number two. And number three is just make sure you've got written records to help support what you're saying. This goes to number one too, which is make sure that you're documenting what's going on and make sure that you're having these simultaneous records that are contemporaneous in time, meaning at the same time that you talk to somebody, because ultimately the employee is probably going to say that you never talked to them and they were doing great. And dealing with these lawsuits, it's sensitive. You got to have somebody who knows what they're doing. We've had cases where we have big firms who were representing the client beforehand, billed them a ton of money, and then drop them just before trial because they didn't want to try the case. And then we've stepped in and successfully resolved it within a few months, when those big firms weren't able to do it for a year or years many times, and charge the client tons of money to ultimately just leave them high and dry just before trial. And so it's incredibly important that you've got somebody who knows what they're doing from the very beginning, because in California, it's one-way attorney's fees, meaning if the plaintiff wins, meaning the ex-employee wins their lawsuit against you, you've got to not only pay your own attorney's fees, but you've got to pay their attorney's fees. So there's a lot of strategy that goes into this to make sure that you're limiting your exposure, because even if you win as the employer, you don't get your attorney's fees paid by the employee. So you've got to be really careful and strategic about what you're doing, because a lot of these cases become all about attorney's fees, and plaintiffs will keep lawsuits going. Plaintiffs' lawyers will keep lawsuits going because they know that attorney's fees are a big issue in the case, and they can go try the case if you're not willing, or if you're not set up properly and strategically to either win the case or limit their upside in getting attorney's fees if they win.